Good afternoon, good morning. Welcome to the German Marshall Fund. Thank you all for tuning in to this discussion and presentation today. The road to justice in Belarus, how to hold the Lukashenko regime accountable for its crimes. My name is Joerg Forbrig. I'm Director for Central and Eastern Europe at the German Marshall Fund of the United States, and I have the pleasure of chairing this discussion today. With this session today, we want to take a closer look at Belarus and at an aspect of the political and humanitarian crisis in the country that, in our view, remains as pertinent as ever. The country may have fallen out of the public limelight over the current developments we see in Eastern Europe, the Russian threat of war against Ukraine, international efforts at preventing that. But nonetheless, the Belarusian drama, the crisis, is not over. It began, as you will all have seen, with peaceful mass protests in the August of 2020, followed by a brutal crackdown by the regime of authoritarian ruler Alexander Lukashenka, and a crackdown really that continues until this very day. To put this in numbers, nearly 1,000 political prisoners find themselves behind bars today in Belarus. Upwards of 4,000 cases have been opened, criminal cases against peaceful protesters. Around 40,000 people were arrested over the last 2 years, and nearly 200,000 Belarusians have fled the country for fear of political persecution. This is a state of affairs that raises the important question, what can be done to hold the Lukashenko regime accountable for those crimes against the Belarusian people? Inside of the country, of course, very little seems to be possible to do. The regime of Alexander Lukashenko holds on to power, and despite numerous complaints by citizens, thousands in fact, against police brutality, there has been no single investigation, no single case against any of the perpetrators. This obviously raises the question whether on the international level, there is a better chance of holding the regime of Alexander Lukashenko accountable for some of its misdeeds over the last years. In the country, clearly justice cannot be brought forward anytime soon, but on the international level, clearly there are possibilities. But what are those mechanisms? How can they be rolled out? How can they be applied to Belarus today? And what can they possibly achieve in the short or also in the long term? These are the questions that many of us are asking. Many of us have been dealing with Belarus for a long time. Many of us have followed events over the last year, also tried to help Belarusian civil society and the democratic movement at large. But we all find ourselves faced with that question, what about efforts at justice in Belarus? About a year ago, Eugenia Andreyuk and a colleague of hers, who has to remain anonymous for safety reasons, approached us here at the German Marshall Fund with the idea of putting together an overview of the various international mechanisms that are available or could be applied to the situation in Belarus. And we're very happy that today we can present the outcome of that initial conversation and the research that Eugenia and her colleague have conducted in the meantime. To my knowledge, this is the first comprehensive overview of these international mechanisms. There have certainly been other treatments of the issue, but as far as I can tell, none has done as comprehensively as the paper that we'll be discussing here today. Now, why is an overview needed? Let me underscore this a little bit. I mean, first of all, the many victims of injustice in Belarus obviously deserve for their suffering to be brought forward and to eventually result in justice. Second, Belarusian civil society has worked quite tirelessly over the last 2 years to document all these events and the individual cases. Third, there are several international efforts at justice in Belarus underway. And finally, in the long term, justice will be a central item in political change in Belarus, whenever that moment may come. So what we hope that this paper can achieve is to contribute in all these directions, to help to energize international and also Belarusian efforts at justice in the country. For presenting, for discussing this paper in more detail here, we have an excellent cast of speakers. First is one of the authors of the study, Eugenia Andreyuk, Belarusian-born. She is a human rights advisor at the World Organization Against Torture. We then have Andreas Schueller, who is program director at the International Crimes and Accountability Program at the European Center for Constitutional and Human Rights. And finally, we have Witte, who is Senior Policy Officer for International Justice and Dismantling Structural Racism at the Open Society Justice Initiative. Thank you all for joining us for this discussion. We're really looking forward to speaking to you all. Before we go into the presentation and the discussion, some very few housekeeping rules from my end. First, we will start with a presentation by Eugenia. I will shortly also share the link to her paper in the chat function. It was published yesterday. We will then open the discussion to include Andreas and Eric for their comments. They've been asked to comment on specific aspects of the paper, and we're very much looking forward to your insights. We will then open the discussion to all of you. We will do this by way of the chat function. Please post your questions in the chat function as we go along. I will make sure that we take them all up. I will paraphrase them and direct them at our speakers. Finally, the session will be recorded and we will make it available online at the GMF YouTube channel after the event. With that, let me turn it over to Eugenia for her paper. The link will come up shortly, but for the moment, let's listen to Eugenia and the main findings and conclusions of her paper. Eugenia, go ahead.
Thank you a lot, Joerg, and thank you a lot to Joerg, but also GMF team for both hosting this event, but also for publishing the paper and for all your help and support during this months of preparation. I'm really looking forward for our discussion that is upcoming, and huge thanks to my co-author. So for sure, I won't go in details in description of the situation in Belarus. A very good overview was given by Joerg. However, what is important for me to reiterate here is legal terms and legal qualification of the situation. So while the regime in Belarus have always been authoritarian and have always been involved in human rights violations, what we observe since August 2020, there are massive human rights violations, including fundamental human rights as torture. And what we see now is that human rights violations took massive and systematic scale, and in this way they reached the level of international crimes, specifically of crimes against humanity. And in this way, these violations and obligations that the government of Belarus are breaking, their so-called erga omnes obligations. So this is a Latin term to name the obligations that states have toward each other. So it means that when Belarus violates such obligation, all other states considered injured. Normally in international law, to be considered injured, there need to be some specific laws or some specific damage, however, not in case of these violations. So massive torture in any country basically creates injuries for all other states, for all member parties of Convention Against Torture. And in this way, other states not simply have goodwill and have goodwill to act, but they are obliged by international law to stop these violations. So as the injured state, they need to act. And what we're discussing now, accountability to Belarus, is not simply an issue of political will for other states, but there is an issue of legal obligations. So then briefly, and you'll see this more information in the paper itself, but we give the brief overview of what was done starting from August 2020 in accountability sphere. for Belarus. And before going, I'll just quickly say what was done, but before going there, it's important for all us to keep in mind that accountability, and before bringing to justice, there is two steps, preliminary steps. So first is documentation of violations, when basically everything is documented, and then investigation, what is to find who is specifically accountable for what, and then the final stage is specific litigation or bringing to justice. So what was done before and before today, indeed, a huge effort was taken by Belarusian civil society in support of international human rights organizations to document human rights violations in Belarus. And today we have, I think, around 3,000 cases of torture and other human rights violations documented at least, but also these cases much more. Except this, the efforts for investigation and documentation were taken by international community and by interstate organizations. Organization for Security and Cooperation in Europe, OSCE, has launched Moscow and Vienna mechanisms for investigation of crimes, as well as UN has started its mandate and mechanism for investigation and documentation of human rights violations in Belarus. The report of the mechanism will be presented in March in Human Rights Council in Geneva, and after that it will be decided whether this mechanism will keep working, for what we all hope. And now moving to the most important part, what are the mechanisms applicable now? Indeed, our aim was, and the paper gives overview of all possible mechanisms that could be applicable. And then I think it's for us here, but also in other formats, to discuss what of them are more effective and what would be and should be applied first of all. So overall, all the mechanisms are divided in the paper, and I think for sake of discussion, to be it easy, in two huge types. One, it's individual criminal responsibility. So here we're talking about bringing to justice specific perpetrators of specific crimes and violations. So it's about individuals and individual liability. The second type of responsibility is state responsibility. So not simply only individuals are responsible, but Belarus as a state, as a government, are responsible for human rights violations. So when we talk about individual mechanisms, it's here we talk about International Criminal Court. While Belarus has not ratified the Rome Statute, however, potential is to go to ICC via crimes, trans-border crimes, here mainly forced deportation of citizens of Belarus who were forcibly displaced from the country. There is a discussion whether it's effective or not. However, as a mechanism, it's there, and for sure, situation could change, and with the changes in the country, the Rome Statute could be ratified. There is a huge mechanism of universal jurisdiction. Some cases already have been started, and I'm sure we will discuss it more. But basically, what is important to keep in mind, universal jurisdiction is basically national investigation by other countries within their national criminal procedures. And they can and have a right to investigate it because of this gravity of the crimes. And then the last option, which is probably more for future, but the possibility of ad hoc tribunal for specific criminals and for specific situation in Belarus. I am sure we will discuss it more, especially Eric will give his feedback and expertise on this. However, there are different formats and options for future ad hoc tribunal to be established. The second bunch of mechanisms for state responsibility, here mainly two potential institutions. First of them is for sure International Court of Justice, the main judicial court of UN system. And while Belarus has not committed itself to compulsory jurisdiction of the court, however, some international conventions could be used to go to International Court of Justice. And here we count on other states which could file complaint to International Court of Justice against government of Belarus. These conventions are mainly, they are described in details in paper. This is Convention Against Torture, this is Chicago Convention for Civil Aviation, as well this is other human rights conventions. Also potentially now with migration crisis, another convention that could be used for this is Convention on Organized Crime. And the second huge type of mechanisms for state responsibility is UN treaty bodies, which also could be used for interstate proceedings within their scope. And finally, we also describe some other mechanisms which could be involved, as in the sport law, for example, or environmental law, which could be activated depending on the situation and how situation evolves. So finally, to conclude, why accountability is important. And it's important to keep in mind that accountability and impunity, it's not only issue for Belarus, but Belarus is a huge illustrative example here of what could be done in these situations of authoritarian regimes that commit more and more violations and that do not ratified instruments for compulsory jurisdiction of international courts. Practically, in practical terms, accountability could bring specific legal remedies for citizens of Belarus, as they don't have access to now to them, and in some sense restore rule of law. For sure, it will deter and will suspend a bit of repressions in the country and will have immediate effect there. And finally, it will contribute to future transitional justice and to future proceedings at the national level in Belarus. So I hope that this year, overall, as international communities, there will be more focus on accountability. There will be more practical steps to reach and to bring accountability to the people of Belarus. Thank you a lot.
Thank you very much, Eugenia. This was a very concise, very quick, and very well structured overview. So even for the non-legal experts among us, I think it was very accessible and easy to follow. Many thanks for this. Let me turn it over to Andreas for a first set of comments from his end. Andreas.
Yeah, thank you very much. And also thank you very much for having me at this event. And I'm also very happy to comment on the study and to have access to the study, because I think it lays out the landscape pretty well on what are the options, what's out there, what does international law, international institutions provide when it comes to justice and accountability in Belarus. Of course, the biggest question is how to make this practically available, how to make it functioning, what's the strategy to use or to initiate such procedures, mechanisms, courts, and so on. So I think that's one of the important parts we're going to discuss here, but not only here, but also at a number of other, of course, meetings and collaborations and so on. And let me start by saying that certainly one important thing is the time and the time perspective we are speaking about here. So, is it something, we want to address, achieve, trigger in the next, 6 months or a year? Or are we talking about time dimensions of 5, 10, 20 years? I think that's important to have in mind when we talk about the topic of international justice, because we know from history, from other situations, from other countries, that it's an extremely long topic that can last for many years, even generations. Coming from Germany, of course, there are still Nazi trials in German courts today, 70, 80 years after the crimes. Of course, with a different meaning, different perspective. Looking into crimes from Latin America, the dictatorships in Argentina, Chile, and so on, there's still trials going on 40, 50 years after that happened. And looking into Syria, for example, where we just had this decision by a German court in Koblenz in one of the, or in the first case against members of the Assad regime, that was already also 10 years after the crimes happened, basically in 2012. So I think the time dimension is quite important to inform the use of the mechanisms, the strategy, expectation management, what we can expect in terms of justice and accountability mechanisms. And that needs to go hand in hand, of course, also with the political transformation, hopefully in the country, the perspectives, the also the growth and the discourses in society and so on. So I think that's all important to see in the broader picture. Then probably zooming a bit more in, it's also important that any processes are victim-centered, that they allow for storytelling, give space and safe and secure space to bring this forward, because I think that's also extremely meaningful and important if we talk about justice and hopefully also some transformative processes in the country over the next years to come, that those stories are out in a safe space, and that the people affected by the crimes mostly, so the direct victims, have a stand here, can give their opinion, their views, their perspectives into the documentation procedure, but also then into various mechanisms and justice procedures. And this transforms back then to developments in the society, which hopefully will be a democratic one and where all human rights are respected. This brings me to the point of the situation that peaceful protests were attacked and repressed by the regime in Belarus in a form that amounts to crimes against humanity, so with extremely violent means. Some are mentioned, torture, arbitrary detention, crimes like that. And that also shows that all too often, not only in Belarus, in many other countries, you have peaceful demonstration, you have the exercise of human rights, which are repressed, where you have a crackdown, and often with means that amount to international crimes, and that also need to be called out as international crimes, and that need to be addressed as international crimes at those levels and mechanisms Eugenia pointed to in her study. Maybe very briefly on one of the main aspects we are working on at ECCHR on universal jurisdiction cases. Also here, we would need a European response, not by single countries, because the dimension is too big. The evidence is spread in many different countries and jurisdictions, so you need this cooperation. And I think within the EU, with Eurojust and Europol, with joint investigation teams, states could agree on. There are mechanisms available which need to be used by states in terms of cooperation to build cases that could be prosecuted in courts in some of the European states under the principle of universal jurisdiction. But first and foremost, it's important that there's a good documentation, that evidence is secured, and that states come in a form and mechanism and understanding of collaboration, because otherwise I fear that we would maybe see some very individualized cases, but not the bigger picture investigated. And it's important to document and investigate now, and not only in 5 or 10 years when there's more political space or there's a case coming up, because you're losing evidence, and only if you start immediately with documentation and investigations, you can later on bring those cases successfully in courts and prosecute them. So I want to stop here. That was a very brief reaction to the study and how to make it practically possible, hopefully, to use those mechanisms. But I'm, of course, very happy to further discuss it later on. Thank you very much.
Thanks a lot, Andreas. I think you raised a couple of very important points on expectations, also on what is needed from a number of stakeholders. So I think this was a couple of very good hooks also for our discussion already. Many thanks for this. Over to Eric, who has joined us. Welcome, Eric. Good to see you here. Over to you for a set of comments from your end on the paper that Eugenia and her colleague have just published. Eric.
Thank you very much, Joerg, and thanks to the German Marshall Fund for having me today. I'd like to congratulate the authors on a really helpful paper, providing a really solid overview of all the different possibilities and pathways to accountability for these crimes in Belarus. And you know, the way forward may require some choices, even if there is a preference for an all of the above approach to accountability. there should still be thinking about priorities and perhaps sequencing, taking into account the point Andreas made about timelines and sort of assumptions about, well, first the realities of, how long different processes generally take given past experience, but also assumptions about, what kind of timeline you're looking at. Is there an assumption of democratic change in the future, the near future, or is it the more distant future? Because that might affect which processes are preferred or should be prioritized. I think we should also acknowledge the huge success already in preserving evidence and documenting the crimes, with the establishment in particular of the International Accountability Platform for Belarus. You're already way ahead of civil society in pretty much any other context I can think of, in terms of having some kind of mechanism with a mandate to collect and preserve evidence to a criminal standard. And that will, of course, be useful for a variety of the ways forward. A few comments. As the paper notes, universal jurisdiction in Lithuania, Poland, and perhaps other EU countries is the most immediately accessible path to prosecution of torture and other crimes in the near future. I think more critical thinking needs to be given to any path that would involve the UN Security Council, I think for obvious reasons, anticipated obstruction from Russia and China, to any creation of an ad hoc tribunal through the Security Council, and any referral to the International Criminal Court. And similarly, I think sort of other efforts to engage the International Criminal Court based on the Myanmar precedent seem a bit like a long shot to me, though I'd say, perhaps they should be considered in terms of their advocacy value, because those kinds of filings can help to underscore the gravity of the crimes and build towards other processes. The mention in the paper of the treaty-based court, I think, is something worth further exploration. And it's an idea that the Open Society Justice Initiative has looked to in relation to Syria. It's our view that there's no legal obstacle to countries pooling their jurisdiction, including their universal jurisdiction, to form a court with its own statute. And we believe that statute could exclude immunities for official functions that apply at national level, which could be a big advantage for a treaty-based court over universal jurisdiction. A dedicated court, of course, could potentially provide more comprehensive accountability for these crimes than is possible through, probably what would only be a handful of cases that could be achieved through universal jurisdiction or other efforts. To go down this path, it would be important to find a partner state to lead the effort, and to identify a set of states that would likely, or at least consider joining such a treaty. And the broader the base of such a treaty, of course, the better in terms of legitimacy, in terms of financial support, political support for any court that's created. And then when it comes to the design of such a court, there are an enormous variety of questions and possibilities. And there's no need to sort of think about any particular model as a template, any model that's come before, even of the, setting aside how it was created. But it should be designed for Belarus and for the needs of the victims and of civil society and Belarusian society at large. And in putting together a handbook called Options for Justice, we looked at 33 past mechanisms or proposed mechanisms in 29 different states and tried to sort of break it down into different areas of design. And starting really with what's the purpose of a court is it only to hold a small number of those most responsible to account, or does it have broader aspirations to, prosecute every perpetrator or something in between? How is that defined? What relation does it have to truth-telling processes, say, or other transitional justice mechanisms that may arise to provide reparation or to memorialize these crimes? What would be the hope if there is a democratic transition? How would any court that's created in the near future, in the coming years, relate then to sort of a new justice system in Belarus? And can that be planned for at the outset, so that if there is a democratic transition, that this court is sort of an investment in judicial independence in a new Belarus? Is this something that might be based outside of Belarus at the beginning, but if there's a transition, moves into the country, changes in composition in some way to become more Belarusian than international in nature, and really help to jumpstart justice sector reforms? What is the legacy? Is sort of another way of putting what was the hoped for legacy of any such court. And what are the structures that would reflect all of these hopes and aspirations, and also the constraints? And it would be important for Belarusian civil society to engage in a discussion with any states who might be interested in this idea about what's realistic in terms of design and aspiration. And I think I'll leave it there for now, but I'd be happy to come back to that idea later and say a bit more. Thanks again.
Thanks a lot, Eric. There were quite a few sort of items in what you mentioned that I think we should absolutely come back to also in the discussion. I think there's at least one addition basically to Eugenia's paper, if I remember correctly, and that's the idea of pooling jurisdictions. I think this is something that I hear for the first time and find very intriguing idea that we should discuss. With this, let's open to questions also from the audience. I see there are already 2 questions in the list. Now, the first of these is obviously the question that runs through all the considerations here. Andreas earlier on mentioned that there is something to be done about expectations. Some of these mechanisms take a very long time. This question here asks, when can we see the first criminal case against certain persons from Belarus? Perhaps we leave that question until the very end, because perhaps against the background of what we're going to discuss, we will get a bit of a sense, all of us, what the timeframes here might be. There also is a second question that I'm going to dismiss with your permission, because it's a question that is about the current situation between Russia and Ukraine and the involvement possibly of Belarus thereof. This is far beyond the topic of this session. I'll invite everybody in the audience to post their question either in the chat or in the question and answer function of this system. In the meantime, let me perhaps turn to our speakers on this issue of universal jurisdiction. This was mentioned by Eugenia, also by Eric in particular. Eric also mentioned some of the countries that are looking at cases from Belarus in their individual jurisdictions: Lithuania, Poland, Germany. To the best of my understanding, there are quite some differences between those countries. Not all countries have signed up to the principles of universal jurisdiction in the same way. Not all countries are sort of going that route in the same way. Perhaps the 3 of you could give us a bit of a sense of the differences that there are. We know that Germany is going quite far with this. Other countries are more reluctant. Perhaps you could, because this is such a central mechanism and a new one really in many ways, you could add some detail to this and perhaps help us understand where the potentials are and where the constraints are also for this. Eugenia, you want to go ahead with this?
Yeah, I could start probably with even more practical things, because I'm sure Andreas will provide more insightful things on specificities. As someone working with jurisdiction, and actually will use the opportunity to congratulate Andreas with the recent judgment on Syrian case, which is surely a very great news for every one of us who are working on universal jurisdiction. So from my perspective, and I would just give related to Belarus things. So indeed, universal jurisdiction is different because it's basically national mechanisms, and that's why we depend a lot on national law and what provide national law, but also in practical terms, how much experience and knowledge every state and prosecution office has, and how they build their work. For Belarus, in practical terms, we depend here on specific victims, witnesses in these countries. So despite the universal jurisdiction sounds very wide, in practical terms, absolute majority of states still need people who could complain in their territories. So for sure, the largest number of people and victims of human rights violations we have now in Lithuania and Poland. And while in Lithuania, indeed, there is already opened criminal investigation, we have, I think, more than a dozen of specific complaints, and they're all now united either under one investigation on torture. In Lithuania, there is also ongoing investigation on incident with Ryanair flight and basically hijacking of plane, which is, I think, close but not the same. So we see that Lithuanian prosecutor is working on this, and here we see some more practical constraints as for Lithuanian prosecutor. It's basically the first time when they deal with universal jurisdiction, and for sure they need in some sense more time, but also, I mean, it's new for them. They need to organize their work now. In Poland, we have, unfortunately for now, legislative constraints. In Poland, only citizens of Poland could apply and could become parties in universal jurisdiction cases. So there is also ongoing investigation, but it's related to detention and torture of Polish journalists. I know that human rights defenders work there to the ways how to get non-citizens in the process, but it seems now a bit challenging, and we hope either for changes in legislation or also for some practical implementation. So Germany, I leave totally to Andreas. There is also some victims in other countries, as in Czech Republic, while it's also quite challenging, as Czech Republic has never dealt with these cases. It's quite challenging for prosecutor office in practical terms to start. And then finally, the practical needs that we have now, it's a question for victims and witnesses who could apply being in different jurisdictions. Because for sure now with the level of repressions and persecution in Belarus, many witnesses are afraid to complain, as well as in some jurisdictions there is a need for practicing criminal lawyers who would work in national jurisdiction with these cases. So this is a bench of some practical things related to universal jurisdiction, but for sure I give the floor to my colleagues who I'm sure would have also other things on this.
Thanks, Eugenia. We'll take note of this question of documentation, and we'll come back to it because I think it is a very important one, what you mentioned towards the end now. But for the moment on this question of universal jurisdiction, Andreas.
Yeah, thank you very much. Of course, there's a lot to say because the criteria are different from country to country, so that's makes it so complex, and there are many different factors that are important in one country, not so much in the other. So I'll try to draw some lines here. So one is, of course, the legislative aspect. So what's in the law on universal jurisdiction, and in many European countries, you see that it's under certain conditions, and one condition is often the presence of a suspect on the territory of the state. So that's the case for France, for Switzerland, for the Netherlands, for Belgium, where you can only have cases if a suspect is present on the territory. It's not the case in Germany, not in Sweden, as far as I know, that the presence, that you have such a presence requirement. So there, for example, in Germany, German prosecutor can also start investigations and securing evidence when no suspect is on the territory, and could go even that far to have extradition requests or first arrest warrants, basically, to then file extradition requests to get those people to Germany to stand trial in Germany. Whereas in other countries, on the other hand, in France, for example, on the one hand, you have the presence requirement in universal jurisdiction cases, which limits, of course, the possibility to start investigations. Of course, there are other factors that if you have people with EU nationality, with a German or French citizenship that became victims of a crime in Belarus, they could also bring their cases in those jurisdictions. In Germany, in France, so then you don't have the presence requirement because you have a victim from that country, and that could also trigger investigations and procedures. So that's another factor here. And then strategically also, we have to see that in a country like Belarus, similar bit with Syria, ongoing conflict, not so many of the perpetrators have left those countries and are probably found in some European jurisdictions, whereas in other cases, like in Rwanda for the 1994 genocide, in cases on Liberia, now on the Gambia, there were regime changes. So a lot of the perpetrators suddenly had to leave the country and are now found in other countries, which would more easily trigger universal jurisdiction. So that explains a bit the differences, why you see some more cases in those situations and some less situations in other cases. Nevertheless, on Syria, for example, we see some cases which on the one hand depend that Germany, but also France and Sweden opened so-called structural investigations, meaning that they collect evidence very broadly and also share it to build cases. Whereas in other cases, you only have so-called personalized investigations, which go only into a specific case or against a specific perpetrator, so they're much smaller, much more targeted. But especially those structural investigations are very important at the very beginning to have a broad spectrum of potential crimes, of evidence, and out of them you can either develop cases towards arrest warrants, also against very high-level perpetrators. And on the other hand, you are prepared if a suspect happened to be on your territory or there's a possibility to extradite someone, that you don't start from zero, but that you have already a pool of information, evidence to start those cases. That's why also documentation is so important. I think we will come back to that. But those are some of the criteria that are important. Whether you can see that a case goes forward or not. Overall, there is the EU Genocide Network. It's under Eurojust, a network where from all European countries some focal points meet. So war crimes units, prosecutors, police regularly. So also states Poland, Lithuania, Czech Republic who start proceedings and are not that experienced yet with those kind of cases. Hopefully through the networks, through the support by more experienced countries, also get the knowledge and the skills how to build those cases, how to investigate and prosecute those cases. So also on that level, there are some mechanisms in place which hopefully strengthens those cases in countries where you have a lot of victims living now, like in Lithuania, and we also see from history that the more migrants are in a certain country, the more, I would also say, is the likelihood that cases will go forward there, because you have all the stories there, you have the political pressure there, you have the evidence there. So it also means, of course, where a lot of survivors are in those locations. Yeah, every effort should be done to build capacities also there with local authorities and prosecutors, police, to be able to bring those cases forward. Because most countries have legislation in place, but not necessarily war crimes units and experience.
Thanks a lot, Andreas. I think what we've heard from Andreas and also Eugenia before is a whole sort of lot of arguments that speak in favor of pooling jurisdiction. That's what Eric also mentioned earlier on. I mean, this is about pooling investigative resources, bypassing some of the presence requirements, taking advantage of the presence of larger groups of refugees from Belarus in this case, in some countries, but not in others. Eric, what are the prospects for, let's say, within the European framework on the EU level? Within that space of jurisdiction to be pooled in order to benefit cases, for instance, from Belarus, but certainly also elsewhere?
Well, I'd say there's been no formal precedent within the European Union for pooled jurisdiction, certainly as a treaty-based court. So the precedents for any kind of treaty-based court, Nuremberg, is one, and the Rome Statute itself is the other sort of partial precedent for a treaty-based court. The European Union has established a court for Kosovo, which is formally part of Kosovo's justice system, though the Kosovo Specialist Chamber sits in The Hague and deals with a particular set of crimes. So I think that's a potential way forward. I mean, Andreas mentioned, the EU Genocide Network as being an important center for consultation and collaboration among national war crimes units and other actors who are active in these cases across the EU. There are other ways in which states have supported each other within the EU and outside of it on complex cases. So for example, states can form joint investigative teams across jurisdictions. And there's a joint investigative team with regard to Syria between Germany and France and Sweden. With regard to the downing of the MH17 flight in eastern Ukraine, there was a joint investigative team that included, or led by the Netherlands, but it included Ukraine and Malaysia. And I know Ukrainian prosecutors who were very inexperienced in that kind of very complex investigation and prosecution found it immensely helpful to be working with experienced Dutch colleagues and at the same time have a real voice in the case. So there are those sort of precedents for helping each other across jurisdictions and helping countries where there's less experience. So for example, if there were a transition in Belarus, there could potentially be a JIT that includes Belarus and other states. I mean, there's a lot of room for creativity in drawing on precedent. And again, I would just urge everyone in thinking about options to keep that creativity in mind and to discuss what's possible, among yourselves as civil society organizations, but also with international partners who have been supportive in many ways already, including through support of the International Accountability Platform for Belarus.
Thanks a lot, Eric. It seems there's clearly a field here for advocacy and for some form of additional pressure, especially in the European fields, to make better use of these sort of pooled resources and possibilities. Let's transition to two questions that have come up in the chat. One from Victoria Fyodorova on the ICC. So we're slightly shifting perspective to a different format here. where is the ICC's potential for addressing some of the repressions and crimes that have appeared in the case of Belarus, especially the issue also of deportation from the country. And the other question from Ilya Nuzov is to do with mediation. Whether or not any of you are aware of efforts to reach out to Belarus, to the regime in Belarus, in mediation formats and efforts, whether this is something you're aware of and can elaborate on. Who would like to go first? Eugenia, shall we stay in the order of women first, ladies first?
Yeah, I could start, but also a bit correct that I think Ilya's question is more about International Court of Justice. So what we've mentioned of interstate mechanisms of Convention Against Torture. So yes, and I started with this. So yeah, well, so as far as I know, indeed, so this is one of the mechanisms that is now being discussed among different states, and I know that some states which are closely involved and closely working on the situation on Belarus, some of neighboring states, are considering this option, whether to go to Court of Justice. However, here I think we have a bit of the same dilemma and difficulties as for universal jurisdiction. So those states which have more information, also practical and more applicants, they have less experience in this. While those states which have more experience in going to International Court of Justice. So I remind to the audience that Netherlands, for example, has announced several years ago that they are planning to start this mechanism against Syria, and they have started this mediation, which is an important step before going to ICJ. So those states which have more experience, Belgium has also a case in ICJ on Convention Against Torture. They have less direct interest in Belarus. So I think that this is also the process that we will witness this year. And I hope that as members of civil society, we could also advocate and move a bit this issue of interstate mechanisms. And I'm sure there is also a lot of space for advocacy and further action here. And I think it's more issue of political will, either than practical obstacles to go to International Court of Justice. As for ICC, I mean, I will say my opinion, but also happy to hear from colleagues. Indeed, on ICC, we had just one submission, which was done by several civil society organizations, and it was submission to Prosecutor's Office of International Criminal Court. And as I've mentioned, indeed, it's quite complicated. Belarus has not ratified Rome Statute, so it could be either this strange way via deportations. So I think as overall, ICC is quite a complex mechanism, even for states who ratified Rome statutes. I mean, my advice would be to civil society organizations is to use it now as more complementary mechanism. So I mean, like forwarding their documents and reports that are produced, but I'm not sure whether right now it's a good time specifically to start working on ICC and specifically like using unfortunately limited resources, but yeah, interesting also to hear the views of colleagues. Maybe there are some things that yeah, I don't see in some important aspects.
Andreas, Eric, you want to come in on these two questions? Andreas.
Yeah, sure. And actually, I agree with Eugenia that on the ICC, for example, on the one hand, there are limited resources for the court, given that basically they investigate, I don't know how many situations at the moment in how many different countries, with a rather comparatively small team. I mean, comparatively to some of the treaty-based or ad hoc tribunals that have much more resources for one specific situation. Partially due to the amount of funds they get from member states. So, but on the other hand, also I think at the moment the Office of the Prosecutor is focusing on some specific cases, and they are not very much open to add many more cases to their case docket, especially those that are jurisdictionally already difficult, because you need to make this argument with deportation into a static country and create jurisdictions through that move. That has been tried in 3-4 other situations already after the decision on Myanmar, Bangladesh, where the court found jurisdiction in this really particular circumstance of the Rohingya being pushed to Bangladesh, a member state, by Burmese forces. So there are other cases on Syria and other countries brought with the same arguments, so far not successful. So I also see the likelihood that the ICC will take this up here in Belarus rather low, and of course I would keep it in as a potential opportunity, but it's certainly also nothing I would focus on. The ICJ is I think a bit more interesting. Of course, that goes directly to states, and I think that states that are upholding the rule of law internationally, that want to strengthen public international institutions such as the International Court of Justice and other institutions, they should also use the jurisdiction of this court and other international courts in bringing also interstate complaints and cases there. And the Convention Against Torture offers opportunity to go and seize the International Court of Justice under certain conditions, as well as other international treaties and conventions do, as you can see in the study. And I think there is still some space to better use those treaty-based mechanisms or the jurisdiction of the ICJ, for example, by states to strengthening an international justice system as such, and to address the topic of torture in this case and at Belarus before an International Court of Justice. But to my knowledge, not unlike the Netherlands, supported by Canada in the case of Syria, that has happened in the case of Belarus. And certainly there would also be a number of other countries being candidates basically to be brought before the International Court of Justice. So I would again deem that important for states to take the step. But I know that many states are either not experienced or reluctant or don't have different opinions to see what it means and what the results would be of such a move here. So these are some of my views on those questions.
Thank you, Andreas. Eric, you wish to comment on this question or these questions?
Sure. And I would really caution about placing hope in the ICC and raising expectations that the ICC is ever going to do anything on Belarus. And I say that as a supporter of the courts and indeed as a former staff member. But as Andreas noted, has very limited resources. It's just very unlikely that, given all of the constraints on those resources, staff and financial resources, that the prosecutor would accept a very thin argument or narrow argument to assert the court's jurisdiction when comparing the situation in Belarus with all of the other places around the world with atrocities where jurisdiction is much clearer. And even if and when the ICC would act, it's has a track record of being very slow, of only ever bringing a few cases in any one situation, and it struggled to prove some of the prosecution has struggled to prove its cases in court against the highest level suspects. There can be advocacy value in filing complaints with the prosecutor, as has been done following the Myanmar precedent. But again, I would urge some caution, because that's in relation to a narrow set of crimes. And if the main crimes at issue in Belarus are torture, it's hard to include them in a deportation filing. And then finally, it can often be misunderstood when you're conducting advocacy with the ICC. If you're filing an Article 15 submission with the court and you put out a press release, some journalists who are unfamiliar with the ICC and the restrictions on his jurisdiction misreported as, there's an indictment against Lukashenka or whatever, I mean, something that didn't happen that raises expectations among the population, only to be dashed later. And there's sort of a long trail of disappointment in the court for reasons of its own making, reasons of the international community's making, for reasons of misunderstandings. And in the region, if you look at the situation in Georgia, I think a lot of Georgian civil society may regret having gone down the path of trying to engage the ICC.
Thanks a lot, Eric. While our audience thinks of further questions, I have one or two questions myself. I mean, one is about the selection of cases. I mean, clearly with a number, as we have seen in Belarus, it won't be possible to bring to justice everybody and to pursue each and every case. So there must be some form of prioritization, sampling perhaps. I was wondering whether you could sort of let us know a little bit from your experience how that works in practical terms. Are there crimes that are being prioritized over others, cases that are prioritized over others, or is it rather about trying to place a cross-section of the full range of misdeeds, as it were, by the Lukashenko regime before international accountability and justice mechanisms? How does that work? How does that work technically? And related to that is obviously the entire issue of documentation. I mean, in order for taking any of these cases to mechanisms internationally, for holding Belarus accountable, there must be a pretty strong set of documentation. What is the experience so far in bringing together a substantial evidence body? We know of many efforts by Belarusian civil society. Eric, you mentioned the International Accountability Platform. What is the experience so far, and what needs to be strengthened in this documentation system, or in the building of that body of evidence, in order to, in the short and long run, stand a better chance of success before courts? These two questions, perhaps at this stage. We'll stay in the order with Eugenia starting.
Yes, thanks. So then we'll start with documentation. So for sure, documentation depends a bit on the situation in the country. And we've seen and we all observed different stages of documentation. In the very beginning, it was a huge number of people, of witnesses, victims who were ready to provide their testimonies and to be documented. And in some sense, it made the work of human rights defenders and human rights organizations a bit easier. I mean, it was really a huge number of people who were not afraid. Unfortunately, the government took the policy not simply not to investigate cases, but also specifically active policy to put in prison and to prosecute victims and witnesses of torture. And we see that in a number of important cases, as murder of civilians, for example, the main witnesses were imprisoned for more than 10 years. The same thing is going on with other witnesses. So the police specifically came to people who complained on torture. So for sure, after this, the number of people who wanted to give their testimonies decreased significantly. And now my colleagues who are documenting torture are working in quite difficult situations also themselves, as a majority of Belarus civil society were persecuted themselves. Many organizations were shut down. Many people were forced to go abroad. So now I would say that it's also rebuilding the system of documentation to keep working in the present day circumstances. Now a lot of work is done, a lot on criminal prosecution, politically motivated prosecution, political prisoners. So it's still challenging, I would say, to keep documentation up to date. and to keep connection with victims and witnesses who keep staying in Belarus. Together with this, a number of people went abroad, and this is potentially future work for universal jurisdiction cases and for future complaints. So for efforts that have been done, and indeed international accountability platform is very important step. Together with this, with full respect, we are also supporting and working with this. It's important in global scale to keep in mind that international accountability platform is still initiative of NGOs. And in order to document and bring further processes, it shouldn't be restricted and limited only to civil society. That's why this UN mechanism that now is working under Office of High Commissioner for Human Rights that investigate and document human rights violations is so important and essential. And I hope that Human Rights Council will further prolong its mandate, because now they have been working basically only since October to this limited period of time, with underfinanced as many other mechanisms. So what here we need with documentation is basically to move further from civil society. So great work is done by civil society and will be done, but we also should engage more UN as well as more universal jurisdiction, because in some sense investigation and documentation is also done via criminal investigation itself. For priority, while it depends on situation, I mean in normal traditional situation, a lot of prosecution is when national government is willing to do this, a lot of done at the national level, so more low-level perpetrators is prosecuted at the national level, while international bodies are work with more high-level command in normal situation. I think here now in Belarus we are working with what we have, and in some sense, based on what I said, we are quite limited. We don't have all freedom to prioritize cases, to choose. So we are working with witnesses, victims who are ready to go for further mechanisms, and among them for sure it's based on seriousness of crimes, on what evidence we have here. So but indeed it's more technical issues, and maybe my colleagues will provide more details.
Thank you. Over to Andreas on either one or both of these aspects.
Yeah, thank you very much. I can only repeat how important documentation is from very early on, through structural investigations by police, through the UN with a strong mandate also to build files for prosecution, like the IIIM on Syria, for example, but then also with the International Accountability Platform for Belarus, which we at ECCHR are also supporting, which is of course also a new mechanism which is meant to be there really quickly and shortly after, or basically during the crimes are still happening, or while the crimes are still happening, to start from the very beginning in a combination of international experts, international NGOs with local NGOs to document, to secure evidence already in a good level, in a coordinated way, in order then also to inform the UN or national prosecutions with that information. Because again, the time is a factor here, and it's important to be there very early on to gather all of that. And technically, there's so many means now also for civil society to do that, with cell phones, with all other forms of databases, and it's also in the study the civic tech part of the documentation, and platforms to collect testimonies and all of that. So there are a lot of possibilities for civil society, for citizen journalists to collect, but it needs to be coordinated and to certain standards. And I think what's also very important, coming also to the case selection, is that from very early on there is an intersectional or cross-sectional approach, because if you leave aside certain set of crimes or elements of crimes in the documentation, it's extremely difficult to bring them in at later stages. And and I think that's so important that in the way documentation processes and mechanisms are set up, they inform already what will come out maybe 2-3 years later in terms of a prosecution and shape the direction it's going. And so that's why it's so important at the very beginning to do this intersectional analysis of the conflict, to see what international criminal law offers. You have, for example, the crime of persecution for various discriminatory grounds on race, on gender, and other aspects. That's quite different crime compared to torture or also then murder or enforced disappearances, which are all crimes under crimes against humanity, but they have different context, different background, and different meaning in society, and they address the different aspects of crimes. And if you look into attacks on peaceful protests, on shrinking spaces for civil society still going on in Belarus, especially those documenting, which is another set of crimes currently happening, I think that's important to analyze and to investigate accordingly in certain directions here and put certain focus, so that in the end, later on, more strategically, you can select the cases and the crimes if you have either domestic mechanisms to do that independently and impartially, or if you have UN mechanisms to do that, or an international court, because one must also say that a universal jurisdiction case is mostly based on opportunity, because a suspect happens to be in a foreign country, and then it's this case, but it's not a strategically chosen case. You can only see within this very specific case if there are different directions you can take, but often it's then predetermined on the person, basically how the case looks like. So I think these are factors which are extremely important for documentation and strategies, how you set that up to use also the full range of potential crimes for later prosecutions, that then also transform back and be reflected in society and in the countries, and also in different groups of victims, because it's also not a homogenic group, but often a quite diverse group, and that also needs to be reflected when it comes to broader justice mechanisms.
Thanks, Andreas. Over to you, Eric. Your thoughts on these aspects?
Well, I agree with everything my two colleagues have just said. On documentation, there's a wealth of experience from previous situations, with regard to how interviews are conducted and who conducts them, avoiding re-interviewing the same witnesses over and over and over again. Sometimes different NGOs want to go and interview the same people for different justice processes, and particularly when you're looking at a range of accountability processes, there may be need for evidence of each, whether it's a human rights claim or a criminal case you're trying to build. And there needs to be real care with that, because when somebody is asked over and over again, they can be re-traumatized, living through the experience of what they've suffered. They may have some inconsistencies among their statements, and then later in court, that could reduce the value of their statement that they eventually give to a prosecutor. So investigators conducting these, and whether for human rights or criminal justice purposes, really need to be trained, and they need to be coordinated. And there should be provision of psychosocial support for victim witnesses who are traumatized. And there are many other lessons, and we talk about it for a week. In terms of case strategy, as Eugenia said, it seems a bit like a luxury at this point to talk about strategy. That you kind of have to work with what's available, given all of the constraints on access to suspects, access to evidence, jurisdictions that potentially could be willing to proceed. Generally, if you had have a dedicated court, a prosecutor can develop a strategy, maybe starting at the bottom and starting with lower level officials and building up evidence, and potentially, if the statute allows it, flipping suspects to testify against higher ranking individuals. Absent that, I think the best hope for trying to develop any kind of a strategy in this kind of situation is the structural investigation, if there's a country willing to do that under universal jurisdiction.
Thanks a lot, Eric. Related to that, let me ask another question from my end, while I call on our audience to swiftly put in the questions you may still have, because we're also coming towards the end of this session. But my question here has something to do with the actual effects any of this can have. I mean, obviously, broadly, this is about justice. We have heard already, and we get the sense already, that this is a very long-term endeavor in most cases. In having documentation done, in having investigations getting underway, in perhaps at some stage also having legal mechanisms kicking in, what sort of broadly are the short and the longer term effects that we can expect? Is it realistic to expect any of this to perhaps influence the behavior of the regime in Belarus or of individuals in that regime? So what are the sort of effects that there may be beyond longer term justice in individual cases? Is something perhaps that we know of from experience in other countries, in other cases? What is your sense on what this combined efforts can achieve in the long run, in the short run, in the medium term? What are your thoughts on this? Eugenia.
So yeah, on short term already, Andreas, Eric mentioned, so it also depends on what mechanisms are activated, because right now we basically have only universal jurisdiction and some individual complaints in UN treaty bodies. So for sure, what we could achieve in short term, what tangible things is Interpol notes for specific perpetrators, but also not immediately when investigation could give arrest warrants on specific suspects. And I'm sure Andreas could tell here more, but also otherwise it depends on when somebody of perpetrators will be in the territory of other states. So this is quite tangible. Otherwise, for sure, all this, what I've mentioned, access to legal remedies for victims and also some assistance to them, what's possible. So this is specific, more short-term things. For sure, for middle term and long term, it's a bit like more easy, as all these mechanisms are more long-term things. And I would just highlight, I think, the most important thing for me for both middle and long term is also generally about rule of law and justice. And I hope that in future there is a contribution for national prosecution when situation changes, and there is there is a first step, which then will be continued afterwards.
Thank you, Eugenia. Over to you, Andreas.
Yeah, thank you very much. I mean, in the short term and for this year and next year, I think there are a number of things I would hope for and expect. So one is that, of course, the International Accountability Platform will continue its work to document, and together with local groups, very much combined with that everyone who's in Belarus, who's in prison there, who's detained there, that those people are set free basically immediately, to stop this continuation of the crimes. That's extremely important. And then from there, that at the UN, there will be a strong mechanism established to prepare strategically also some of the case files. And then on the universal jurisdiction level, that in the next hopefully months to come, that a number of states join forces to maybe create joint investigation teams, exchange knowledge and support each other, and start some structured investigation to also start to secure evidence, especially from survivors outside those countries, and in a coordinated way also at that front, so that you have the accountability platform, that you have the UN and joint investigation teams on interstate level documenting in the hope to then be able to start also some casework and prosecution. That would be more midterm, I think, that we can hope for prosecutions, because either things need to change in the country, or perpetrators need to be extradited or found abroad. But moreover, in mid and long term, my hope would be that the justice and accountability work starting, or that has already started, contributes to transformation of a society, a more democratic one, and maybe also next generation that is quite aware of accountability mechanisms, that's demanding them. It's basically continuation, partially of the demands in the protests that triggered all of these. So I think that's a quite important part. Also, those cases and mechanisms can play when it comes to transformations in society, and we've seen that if you look into Latin America, some countries with more accountability mechanisms, others with less. So societies react and are differently robust to authoritarian regimes or changes there. It's also our hope on Syria that there's a whole new generation that grows up with debates around justice and accountability, that gives also some future to that country. And the same hope would, of course, also be with Belarus, that it's much more enshrined in society, that there is accountability if you overstep certain things, if you commit crimes, especially if you commit international crimes, that that's not acceptable, and the society is not accepting this, and all those people in power or in the future in power have to be accountable to their actions and what they do.
Thanks, Andreas. Sounds like this is all very long term for most of it. Is there absolutely nothing that may result from some of these efforts also in the shorter term, Eric?
I mean, it's useful to think about how the accountability processes available could feed into each other, and it comes back to that question of prioritization and sequencing. Because I do think it makes sense to engage in most or all of these processes, but with an eye to which ones might be able to provide support. Findings from one body, would they be considered by another body looking at another angle of accountability? Which ones are likely to provide media attention, advocacy? It would be important, I think, for Belarusian civil society to do an analysis of, which of these mechanisms are likely to produce findings that resonate the most within their coalition, or within broader society, to the extent that sort of everyday citizens of Belarus are going to gain access to any such findings, information on that. But are these things that how do unenforceable actions by a body play? Do they resonate because they've brought up important issues? So, for example, if you engage the International Labor Organization on violations of labor rights, and there's some adverse finding against Belarus, is that helpful for the coalition because it's highlighting an issue that's of critical importance to some members of that coalition and perhaps to broader society? Or is it frustrating to the coalition because it's not enforceable, And does it make people more cynical? So, and I don't have answers to that question. I mean, that's for Belarusians to decide. But I think those are the kinds of discussions that are needed. And to start mapping out a strategy for, how do you get small short-term gains that give us sense of momentum that can help lead to more substantial gains down the road. And then in the long term, I mean, I think we need to remember that today's politics that make it impossible to imagine, Alexander Lukashenko being personally held accountable for what he's done or his top henchmen have done. That also applied to Slobodan Milosevic in Serbia, to Efrain Rios-Montt in Guatemala, who 30-some years later found himself on trial for genocide in a Guatemalan courtroom, or to Charles Taylor, the former president of Liberia, who was once considered untouchable in West Africa, but was eventually taken to the Special Court for Sierra Leone and is now serving a 50-year jail term in a UK prison. Politics can change, and people need to remind themselves that there's always hope, but also gird themselves for the long term, because sometimes it does take years or decades.
Thanks a lot, Eric. That was a very, very important point. I think that there is an element here of hope that I think we all need to also need to employ. Now, against the background of what we just discussed, I think you're all very well equipped to answer that very first question that we heard earlier on: when to expect a first case from Belarus before an international mechanism. That will be the first question that I'm asking you in this last round of questions now. The second is, if against all of this, you could move sort of resources, as it were, what is it that needs sort of stronger investment at this stage? Is it on the documentation end? Is it the equipment of Belarusian civil society to play its role in all of that? Is it the political attention by individual Western governments? Is it efforts at the EU stage in order to sort of move towards more of a pooling of these mechanisms and resources? If you had your choice and you could sort of single out the one thing that needs to be done way more strongly than it has been so far, what would it be? So first question, when to expect a case, so that we get a bit of a timeline in response to that first question. And second, your priority investment to make these international mechanisms for accountability stronger than they are at this stage. And traditionally, we start with Eugenia.
Well, I would love to say a specific date for the first process and this trial, but for sure, I mean, as from all our discussion today, it takes time, and I liked very much what Andreas said, that it's a bit of based on opportunities. So I hope that quite soon will be this opportunity to have any detainees, because unfortunately there is not possible, and probably there won't be any trial in absentia. So we hope that it could happen as soon as possible. Together with that, I'll remind that some processes also in UN is ongoing, for example, and in November, for example, last year, we had a decision of UN Working Group on arbitrary detention on detention of Roman Protasevich, Belarusian blogger and journalist, and UN stated that his detention was arbitrary. So I remind, while it's not real like trial, but we still have these precedents and they are ongoing, and in UN there will be more precedents, so that it's also like quite multilateral track with different processes going on. As for further needs, I mean, what I would say is that for these 2 years, and especially for those, I'm sure many of our participants who have been doing many things themselves, but also following many discussions, we had many discussions and many different events, as well as many efforts done on documentation. And I think that we should take collectively effort and steps to translate it to more practical steps. So we need more cases on universal jurisdiction, also further to promote joint investigative group will also potentially discuss more things on ad hoc tribunals and pooled jurisdiction tribunal, because it's all based on the specific cases. And for this, we both need the practical work done by lawyers, human rights organizations, but also political will to start these cases despite its legal processes, but also political will is needed here. The same, I hope that this year, once again, going back to discussion of interstate proceedings, that there will be more progress in this, and for here for sure we need more advocacy and once again political will of the states to move forward. But once again, I hope that collectively this year we will see more practical steps on accountability.
Thanks, Eugenia. Andreas, your take.
Yeah, thank you very much. I mean, it's impossible to say when we see the first case and the first trial happening, because as far as I know, all perpetrators are still in the country and will not be extradited. So the question is more, you know, how to build cases, how to document, how to prepare cases, that once you get hold of a perpetrator, to also be able to start a trial. But how this will happen, it's of course impossible to foresee, and that's the main issue. That the perpetrators are all out of reach and in the country as far as we are aware. And overall, I think a lot depends on political commitment in states, in ministries, and in different departments of ministry. So states can do a lot. We see it in the study. There are a lot of mechanisms also states can trigger. Others states can give support to war crimes units, to the ICC theoretically, so that of course there are resources domestically or internationally. Same with the UN, that they have resources at a sufficient level to do their documentation work. So at all levels, it's about resources, it's about political will and commitment, and also some form of creativity. Eric mentioned with probably setting up a treaty-based tribunal or something like that. And that's why it's so important to work at all levels. Jointly with a broad coalition of domestic NGOs, of victims representatives, international NGOs, and like-minded states that are committed, and to build an international coalition, basically to bring those cases forward. But a lot is about political will, commitment, and resources. And if that's there, then you can find ways to bring cases forward, to have accountability mechanisms also doing their work and being functioning.
Thanks, Andreas. Last but not least, Eric.
Yes, I mean, on any prediction of when the first trial might be, I mean, even if everything went perfectly, that there was political will in a country to open a structural investigation tomorrow, and there were resources, and then a suspect became available, we probably still wouldn't see a trial for like 3 years at the earliest, and that's under perfect circumstances. So people should temper their expectations. This is a long haul. As for what's most needed, I would say political commitment. And you know what happened in Belarus in August of 2020 and since is not an isolated incident, and I think states need to not view it as such. There's democratic backsliding around the world, an erosion of multilateral institutions, an erosion of commitment to international criminal justice, with some, you know, welcome advances as we had last week with regard to Syria. But you know, that Belarus can get away with this. You know, it's not happening in isolation. It happens as you know, Russia is poised to reinvade Ukraine, or further invade Ukraine, and you know, other things are happening around the world. And I think this is an opportunity for the international community to reassert international norms, to recommit to the rule of law and international criminal justice by making what in effect is a fairly modest monetary commitment, but putting some political power behind it to try to make a difference.
Thanks a lot, Eric. This certainly is an effort that we all need to be involved in internationally to take this home to our individual capitals and governments, in addition to all the practical work that Belarusian civil society especially is doing, and that deserves also continued support, as we heard from all of you, in a pretty long run. So this is an issue where we're all in for the long haul, and I could certainly only wish us all, the Belarusians in particular, but also all its international supporters, the stamina that it takes to see this through. With that, I'm afraid we have reached the end of our time for today. My apologies, especially to Andrei Novak, whose question I saw too late. But I'm afraid we won't be opening to questions, answers again at this stage. Many thanks to our three speakers, Eugenia, Andreas, and Eric. Congratulations, especially to Eugenia and her co-author on this paper that I encourage all of you to take a closer look at, to see what, in addition to the pretty substantial discussion that we had here, you can learn from that paper. Thank you all for your attention today. Thanks for joining us here. Be safe, stay healthy, and till soon. Thank you very much and goodbye.